Have you ever found yourself wondering what really happens behind the scenes of an arrest?
Yeah.
Beyond the dramatic scenes we often see on TV.
Yeah, or maybe you've thought about how your fundamental rights are protected, even the ones that aren't, like explicitly spelled out word for word in the Constitution.
Exactly. Well, today we are embarking on a truly deep dive. We're going into the very legal scaffolding that underpins our society.
Mm-hmm.
And the goal here is to make you genuinely well-informed on these critical topics.
And building on that, our mission today is really to unpack some of the most critical U.S. constitutional amendments. We're talking specifically the 8th, 9th, 10th, and 14th.
Okay.
And then importantly, we'll examine how they actually shape the intricate workings of our criminal justice system.
Right, the practical application.
Exactly. We'll pay particular attention to how these profound principles are put into practice right here in Texas.
Okay.
Exploring everything from, say, bail procedures to the sometimes labyrinthine court structures.
Definitely complex.
Oh, yeah. And even the specific, legally defined powers of law enforcement officers, like when they can make an arrest without a warrant.
Okay, that's crucial stuff.
Think of us as your guides, helping you extract the most important nuggets of knowledge from what can often feel like a pretty dense legal forest.
And to help us navigate this intricate legal landscape, we're pulling directly from an incredibly in-depth handout. It covers these constitutional amendments, the core components of the criminal justice system, and all the related arrest procedures.
It's a fantastic resource.
Yeah. So this deep dive is really your shortcut to understanding these fundamental legal frameworks, made clear, understandable, and hopefully deeply relevant. So let's unpack this crucial information.
Let's do it.
Our journey begins by laying down what you might call the foundational pillars of our legal system. Amendments 8, 9, 10, and 14.
Right.
These aren't just, dusty historical documents. They are living, breathing tenets that profoundly affect your daily life and interactions with the justice system.
Absolutely. They dictate what the government can and cannot do when it interacts with you. It's fundamental.
Okay, so where do we start? The 8th.
Let's start with the 8th Amendment. This one is all about defining fair treatment within the justice system. Its exact wording states, excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted.
Okay, that sounds pretty clear. Excessive, cruel, unusual.
Right. And that single sentence provides 3 really crucial protections for any citizen facing the power of the state.
So, if we break that down, it means you're entitled to reasonable bail, reasonable fines, and protection against what's termed cruel and unusual punishment.
Exactly.
The spirit here feels profoundly important. It seems like it's about proportionality and humanity, right?
That's a great way to put it. It's about preventing the state from using its immense power arbitrarily or oppressively.
So the government's ability to punish, or even just detain you before trial, isn't limitless.
Not at all. It's designed to ensure that the punishment fits the crime, and that pretrial conditions, like bail, aren't used as a tool of oppression. Making it impossible for someone to prepare their defense or keep their job just because they can't afford some sky-high bail amount.
That makes sense. It ties bail back to its purpose, ensuring appearance, not just punishing before a conviction.
Precisely. And here's where the interpretation of cruel and unusual punishment gets really interesting and often debated.
Okay.
It's vital to clarify what this clause doesn't cover, which is a common misconception.
Ah, okay. Tell us.
The cruel and unusual punishment clause specifically applies to a state's formal post-conviction actions.
Post-conviction, meaning after you're found guilty.
Exactly. It applies to how you are sentenced and treated after you've been found guilty of a crime and are under the formal control of the correctional system, like in prison.
Okay, so what about things like excessive force during an arrest? Or, by a guard in jail before someone's even convicted? Does the 8th cover that?
That's the key distinction. No, it doesn't. Those types of claims, excessive force by police or pre-conviction jail guards, actually fall under the 4th Amendment's reasonableness clause.
The 4th Amendment. Unreasonable searches and seizures.
Right. And, by extension, unreasonable force during those actions. So, the 4th Amendment protects you during the interaction, the seizure, the arrest.
Got it.
The 8th Amendment steps in primarily after conviction, dealing with the sentence and the conditions of that sentence.
That's a really important distinction.
Yeah.
It tells you which part of the Constitution protects you at different stages. 4th Amendment for the encounter, 8th for the punishment phase.
You nailed it. And just to show you how these federal protections are mirrored at the state level, the Texas Constitution actually has several powerful parallels.
Okay, so Texas law echoes this.
Absolutely. Just like the Eighth Amendment, Texas law explicitly addresses fair bail. It outlines specific conditions for denying bail in certain serious cases or for repeat offenders. And critically, it also prohibits cruel and unusual punishment.
So Texas guarantees a right to bail for most offenses.
Generally, yes, mirroring the federal protection against excessive bail. But it also has specific provisions for very serious circumstances where bail can be denied.
Like what?
Well, for example, capital offenses where the proof of guilt is really strong, what the law calls proof is evident, or for individuals with multiple prior felony convictions or those accused of violating protective orders in family violence cases.
Okay, so there are exceptions, but they're specific.
Very specific. It demonstrates this robust dual layer of constitutional safeguards for citizens. You've got both federal and state protections working together, 2 layers of law, not just one.
That's reassuring. Okay, what's next? The 9th Amendment.
Let's move on to the Ninth Amendment. This one is often less talked about, maybe seems a bit more philosophical, but it's incredibly significant.
All right, what does it say?
Its core principle is stated as, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Okay. Enumeration, construed, disparage. That's a bit dense. Let's break that down.
Yeah, it's legal language for sure. Enumeration just means specifically listed or written down. Construed means interpreted. Disparage means belittle or lessen.
So, just because certain rights are listed in the Constitution, that shouldn't be interpreted to mean that other rights, the ones not listed but the people still have, are somehow less important or don't exist.
Exactly. You got it. What it means in practice is profound. Just because a specific right isn't explicitly listed, like, say, the right to privacy.
Which isn't actually written in the Constitution, right?
Correct. It's been established through court interpretation over time, often linked to other amendments. Or think about the implied right to travel freely between states, just because those aren't spelled out.
Doesn't mean we don't have them.
Right. Think of the Ninth as a kind of safety net, a fundamental safeguard against the idea that the government grants rights to people.
Ah, that's a key philosophical point. It's not the government giving us rights.
No. It asserts that people have pre-existing inherent rights, rights that existed before the government. And the founders knew you just can't write down every single right a free people possess in one document.
That makes so much sense. It's a foundational underpinning of American liberty, then. It's saying our freedoms are vast, not just limited to what the government decided to write down.
Precisely. So in essence, if the Constitution doesn't specifically give a power to the government,
then that power stays with the people, or the states, as we'll see with the 10th.
Exactly. It puts the burden on the government to show where it gets its authority, rather than on the people to prove they have a right.
And does Texas have something similar?
It does. The Texas Constitution echoes this in Article 1, Section 2. It talks about inherent political power, reinforcing that idea that all political power originates from the people and free governments are founded on their authority.
It serves as a constant reminder that our rights come from us, the people, not from the government structure itself.
Well said.
Okay, so that naturally leads us to the 10th Amendment. You mentioned states' rights.
Yes, the 10th Amendment is the bedrock of states' rights and this concept of police powers.
Okay, what's the wording?
It says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people.
All right, so powers not given to the feds and not banned for the states belong to the states or the people.
Exactly. This amendment defines that fundamental division of authority between the federal government and the individual states. If a specific power isn't granted to the federal government by the Constitution, then that power generally remains with the states.
And this allows states to govern themselves on a whole range of issues.
A huge range. This is often referred to as their police powers. Now, that doesn't just mean literal police officers.
Like it's broader.
Much broader. It's the inherent power of states to regulate for the health, safety, welfare, and even morals of their citizens.
Which explains why laws can be so different from state to state.
Absolutely. Think about education standards, marriage laws, environmental regulations, even specific criminal offenses like drug laws or gun control measures. States have vastly different approaches because they're exercising these reserved powers to essentially police themselves.
And Texas, I imagine, has strong language on this, too.
Oh, yes. The Texas Constitution reinforces this strongly with Article 1, Section 1, which boldly states freedom and sovereignty of the state. It emphasizes Texas's strong commitment to state autonomy and its unique identity within the federal system.
So the 10th Amendment really sets the stage for understanding why we have both federal and state criminal justice systems.
Critically important, and it's why understanding specific state laws, like those here in Texas, is so vital. A law that's perfectly fine in one state might be a serious crime just across the border in another.
It leads to that patchwork of laws across the nation.
It does. This dual system, while sometimes complex, is absolutely fundamental to the American concept of federalism, that balance of power between the national government and the state governments.
Okay, foundational pillar number 4, the 14th Amendment. This one feels like a heavyweight.
It absolutely is. The 14th Amendment dramatically redefined citizenship and rights, particularly after the Civil War. It's a truly monumental amendment, so let's break it down carefully.
All right, where do we start?
Let's start with the first part, known as the Citizenship Clause. It states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
Okay, born or naturalized in the U.S., citizens of the United States and of the state.
That established a groundbreaking concept for its time, dual citizenship.
Dual citizenship, meaning you're a citizen of both the country and your state simultaneously.
Correct. This was incredibly significant after the Civil War. It officially recognized former slaves as full citizens of both the nation and their respective states.
Which meant their rights were supposed to be protected at both levels of government.
Exactly. Before this, states could and did deny citizenship rights to certain groups within their borders. The 14th Amendment aimed to change that fundamentally.
Okay, what else is in the 14th? It sounds like there's more.
Oh, much more. Then we get to the other crucial clauses, which have had an even more far-reaching impact on individual liberties. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States.
Okay, states can't undercut the rights of U.S. citizens.
Nor shall any state deprive any person of life, liberty, or property without due process of the law.
Due process, that's a big one. Fair procedures.
Fundamental.
Nor deny to any person within its jurisdiction the equal protection of the law.
Equal protection. Everyone treated the same under the law.
Those clauses, passed in the aftermath of the Civil War, fundamentally reshaped the nation. They ensured that all citizens, including former slaves, were entitled to due process and equal protection under both state and federal law. So states couldn't just create discriminatory laws anymore.
That was the intent. Historically, states had significant power to define and limit rights, often leading to deeply discriminatory laws. The 14th Amendment was a direct response, establishing a national standard for fundamental rights.
And it also mentioned something about U.S. law versus state law.
Yes, it clearly spelled out that U.S. law generally supersedes state law when there's a direct conflict. This reinforces the principle of federal supremacy.
So if a state law conflicts with a federal constitutional right.
The federal right wins. It takes precedence.
Okay, so let's recap the 14th. 4 huge concepts packed in there.
Right. First, dual citizenship.
Okay.
Second, due process of lawfare procedures.
Got it.
Third, equal protection under the law, treat everyone the same.
Right.
And fourth, that critical supremacy of U.S. law over conflicting state law.
That last point, federal law trumping state law, I imagine that has created some serious friction throughout American history, hasn't it?
Oh, absolutely. It has been a source of ongoing tension and critical legal battles, and it continues to shape our criminal justice system today.
How does that tension play out now in practice?
Well, think about it this way. When a state passes a law that potentially restricts a right, maybe it's about gun ownership or access to certain medical procedures or voting rights, the question inevitably arises, does this state law abridge the privileges or immunities of U.S. citizens? Does it deny them due process or equal protection under the 14th Amendment?
And that's where the federal courts step in.
Often, yes. Federal courts review state actions to ensure they align with the U.S. Constitution. It means that while states have significant powers under the 10th Amendment,
Their actions are still checked by the 14th.
exactly, Their actions are always held accountable to the overarching principles of the 14th Amendment. This dynamic ensures a baseline of rights for everyone, everywhere in the country, theoretically.
That makes perfect sense.
Yeah.
And the 14th Amendment is often called the Incorporation Amendment, right? What does that mean?
Great question. It's called that because it effectively incorporated many of the protections in the Bill of Rights, which originally only applied to the federal government, and made them applicable to the states as well.
So things like freedom of speech, protection against unreasonable searches, those now apply against state and local governments too because of the 14th.
Precisely. Before incorporation, your state government could potentially violate your right to free speech without violating the U.S. Constitution's First Amendment. The 14th Amendment, through court interpretations over many years, changed that.
So it truly solidified individual rights across the entire country. Your fundamental rights apply just as much against your local police department as they do against, say, an FBI agent.
That's the principle. It's a cornerstone of modern civil liberties law.
Okay, we've built a really strong foundation with these constitutional principles, these big ideas protecting our rights. But how do these grand ideas actually play out when, the rubber meets the road?
Right. Let's trace the journey. Let's follow someone through the system, starting right after that interaction with law enforcement, the moment of arrest, and the often misunderstood world of bail.
Bail. Okay, let's define it first. What is bail, legally speaking?
Okay, according to the Texas Code of Criminal Procedure, you'll hear us refer to it as the CCP Section 17.01 defines bail as security given by the accused so that he will appear and answer the accusation before the proper court.
Security. So he'll appear.
Okay. To put it simply, bail is a legal mechanism. Its main purpose is to ensure that a person accused of a crime, if they're released from custody, will actually return to court for all their scheduled appearances.
Got it. And how does that security work? Is it always cash?
Not always. It can manifest in a couple of main ways. It could be a traditional bail bond.
Like with a bail bondsman?
Exactly, where a third-party guarantor, the bondsman, charges a fee, usually a percentage of the total bail amount, and guarantees the accused's appearance to the court. If the person skips town, the bondsman is on the hook for the full amount.
Okay. What's the other way?
The other common way is a personal bond, sometimes called a personal recognizance or PR bond.
Personal bond.
Yeah. Here, the individual essentially signs a promise to appear. There might not be any money exchanged up front, but they are potentially liable for a certain financial amount if they don't show up. It's based more on their ties to the community, risk assessment, things like that.
So typically a promise backed by some form of assurance, sometimes money, sometimes just your word, and potential future debt that you'll show up for court.
That's a good way to think about it. And in Texas, there's generally a right to bail.
The right to it.
Yes, outlined in CCP Section 1.07. It states that any person shall be eligible for bail unless denial of bail is expressly permitted by the Texas Constitution or by other law.
So bail is the default. It's the norm, not the exception for most offenses.
That's the principle. It reflects the idea that you're innocent until proven guilty and shouldn't be locked up automatically just because you've been accused, unless there's a very strong reason.
Are there exceptions? When can bail be denied altogether?
Yes, there are specific and very limited exceptions. The most significant one we mentioned earlier regarding the Texas Constitution: no bail for capital offenses when proof is evident.
Capital offenses like murder, where the death penalty is possible.
Correct. And it's critical to understand that this denial often applies prior to a formal indictment in these most serious cases. Once an indictment is issued, the situation might change, but pre-indictment denial is possible.
Why only pre-indictment?
The idea is that before a grand jury has formally indicted, the initial evidence presented to the magistrate might be so overwhelming, proof is evident, in a capital case that the risk of flight or danger is too high to allow release under any circumstances. After indictment, the case proceeds differently.
Okay, so it's a specific window for the most serious crimes. Are there other situations?
Yes, the Texas Constitution also allows denial of bail under other specific circumstances, like for certain repeat felony offenders, or if someone commits a new felony while already out on bail for a previous felony, or for violations of protective orders involving family violence. Again, specific defined situations.
Got it. So when bail is allowed, how is the amount actually set? Is it just random?
Definitely not random. CCP Section 17.15 outlines the rules for fixing bail. It's described as the regulated discretion of the judge, magistrate, or officer setting bail.
Regulated discretion, meaning they have some leeway, But there are rules.
Exactly. Their discretion isn't free rein. It's governed by the Constitution and these specific rules to prevent it from being unfair or oppressive.
What are the rules? What do they have to consider?
First and foremost, they must consider reasonable assurance of compliance.
Meaning, will the person actually show up for court if released?
That's the primary consideration. Will they come back? What's their flight risk?
Okay, what else?
They also consider the nature and circumstances of the offense. How serious was the crime? Was it violent?
Makes sense.
And importantly, in modern law, they look at the future safety of a victim or community. This has become a huge factor.
So it's not just about showing up, but also about potential danger if released.
Right. It's balancing the accused's right to bail against public safety concerns, which is a complex calculation.
And didn't we say bail shouldn't be oppressive? How does that fit in?
Crucially, yes. Echoing the Eighth Amendment spirit, the rules explicitly state that bail is not to be an instrument of oppression.
Meaning it shouldn't be set impossibly high just to keep someone locked up because they're poor.
Exactly. It shouldn't be punitive before conviction. And related to that, the rules say the court must consider the person's ability to make bail.
Their financial situation matters.
It can and should be considered. The court can even take evidence on this point. It doesn't mean bail has to be cheap, but it should be factored into the overall decision to ensure it's not effectively denying bail simply due to poverty, unless other factors like risk justify a high amount.
So it's far from arbitrary then. There are very specific criteria guarding judges. Likelihood of appearance, seriousness of the offense, community safety, no oppression, and ability to pay.
That's the framework.
This really helps demystify why bail amounts can vary so dramatically. It shows the layers of constitutional protections against truly excessive bail, aiming for a system that's, well, trying to be fair and proportionate.
That's the goal, balancing all those factors.
Okay, so after an arrest, bail is considered. What's the next formal step? The arraignment.
Following an arrest, the next critical step is getting the person before a magistrate. This is covered under CCP Section 15.1 time, dealing with officer and magistrate arrest duties.
And there's a time limit, right?
Yes. The arrested person must be taken to meet with a magistrate without unnecessary delay. And Texas law clarifies this. It generally means within 48 hours.
The 48-hour rule, designed to prevent people from being held indefinitely without seeing a judge.
Exactly. It's a crucial due process protection against prolonged detention without judicial review.
And where does this meeting happen? Does it have to be in the county where they were arrested?
Usually, yes. They go to a magistrate in the county of arrest just for practical reasons. But the law allows for flexibility.
How so?
They can be taken to an out-of-county magistrate if, say, that magistrate is closer or can see them quicker. The priority is getting them before a judicial officer promptly, ensuring their rights are reviewed early in the process, wherever that might be logistically easiest.
Okay. And what happens before the arrested person actually meets the magistrate? Does the magistrate just walk in cold?
No, there's an important step first. Before even meeting the arrested person, the magistrate reviews the officer's paperwork, the arrest report, the probable cause affidavit.
Why do they do that?
This is a critical judicial check on police power. The magistrate determines if there was actually probable cause for the arrest in the first place.
So they review the legal basis for the arrest itself?
Yes. It ensures that the arrest wasn't wrongful or baseless. It prevents detention if the police didn't have adequate grounds. If probable cause is confirmed,
Then the magistrate can proceed with bail and the meeting.
correct. Then they'll consider and set bail and meet with the arrested person for the formal arraignment.
Okay, so let's define that. What exactly is the arraignment or initial appearance? What happens in that meeting?
The arraignment or initial appearance is that first formal meeting with a judge-like figure, the magistrate. During this brief but vital session, the magistrate performs several key duties.
Like what?
First, they inform the person of the specific charges against them. You have a right to know what you're accused of.
Fundamental due process. Okay.
Second, they review the person's basic constitutional rights, like the right to hire an attorney or have one appointed if they can't afford one, the right to remain silent.
The Miranda rights, essentially.
Basically reminding them of those core rights. Third, they might ask if the person is currently out on bail for another offense, as that can impact bail eligibility for the new charge.
Oh, okay.
And then, Based on all these factors, the nature of the charge and the rules we discussed, they assess and set the bail or bond amount, assuming bail is allowable for that particular charge.
So this is often the very first formal legal step after an arrest.
It is. It's designed to ensure due process kicks in quickly, informing the accused of their situation and rights promptly, and setting the stage for all the court proceedings that follow.
Makes sense. Now, you mentioned earlier that Texas law has specific articles reinforcing the Eighth Amendment spirit. Can you give us examples?
Sure. To further connect back to the Eighth Amendment and its focus on fair treatment, Texas law has several specific articles in the Code of Criminal Procedure that reinforce these protections, often stemming from historical abuses of power that the state wants to explicitly forbid.
Like what kind of historical abuses?
Well, for instance, CCP Article 1.09 simply states, "Cruelty forbidden." It's a direct state-level affirmation of the Eighth Amendment's prohibition against cruel treatment, ensuring humane conditions for those in custody.
Straightforward. What else?
Then you have CCP Article 1.8e, which addresses outlawry and transportation.
Outlawry. Transportation. Those sound old.
They are. These refer to very old, often quite harsh historical punishments. Outlawry basically meant banishment from the jurisdiction. You were declared an outlaw, stripped of legal protection, essentially becoming an outcast vulnerable to harm without any legal recourse.
Wow. And transportation.
Transportation meant being forcibly sent out of the state as punishment, often to remote colonies or penal settlements. Think historical practices of sending convicts overseas.
Okay, so Texas law explicitly forbids those.
Explicitly. Both the CCP and the Texas Constitution in Article 1, Section 20 forbid these practices. It prevents the state from literally exiling its citizens or stripping them of all legal rights as a punishment. It's a powerful statement about individual liberty.
Definitely. Any others?
And finally, CCP Article 1.19 tackles corruption of blood.
Corruption of blood. What on earth is that?
It refers to another archaic practice where a person's descendants could be punished for their crimes.
Punishing the children for the parents' crime.
Exactly. Typically by taking away their inheritance, their estate, money, or even their civil standing, they essentially inherited the penalty or shame of their ancestors' actions.
That sounds incredibly unfair.
Absolutely. And the Texas Constitution, in Article 1, Section 21, also prohibits this. These specific prohibitions against outlawry, transportation, and corruption of blood reflect a deep commitment to individual liberty and fairness.
It's like actively preventing historical injustices from being revisited in modern law.
Precisely. Ensuring that punishments are personal to the offender, not generational, and protecting families from suffering for the crimes of their relatives.
Okay, so the system have all these rules and protections built in. But what happens when police don't follow the rules? When they violate someone's rights during an investigation or arrest?
That's where the checks and balances really come into play. The primary mechanism for dealing with illegally obtained evidence is a powerful tool known as the exclusionary rule.
The exclusionary rule. I've heard of that. It's meant to keep police accountable.
Exactly. It's a cornerstone of protecting individual rights against government overreach.
Where did it come from? Was it always around?
Its modern and widespread application, especially to state and local police, can be traced to a landmark U.S. Supreme Court case, Mapp v. Ohio, decided back in 1961.
Mapp v. Ohio.
Okay.
What did it do?
This case famously applied the exclusionary rule to the states. Before Mapp, the rule mainly applied to federal law enforcement. Mapp made it a nationwide requirement.
So it ensured consistency across the country. State courts had to follow it too.
Yes. It was monumental. It made clear that unconstitutionally obtained evidence could not be used in state courts, just like it couldn't be used in federal courts.
So what is the exclusionary rule, simply put?
It's straightforward in its purpose. It prevents the court use of any evidence that was illegally obtained by law enforcement.
So, if police violate your rights, say, an illegal search without probable cause or a warrant to get evidence.
That evidence generally can't be used against you in court.
Why? What's the reasoning?
It's a powerful tool designed primarily to deter unconstitutional police conduct. The idea is, if the police know that breaking the rules means the evidence they find will be thrown out, they'll be less likely to break the rules in the first place.
It removes the incentive to violate rights to get a conviction.
Exactly. It's the legal system's way of saying, we value constitutional rights so highly that we won't allow the government to benefit from violating them.
Okay. Is there more to it? I think I've heard of something like fruit.
Yes. You're thinking of the fruit from the poisonous tree doctrine.
Fruit from the poisonous tree. Okay, explain that analogy.
It's an extension of the exclusionary rule. Imagine the initial unconstitutional police action, like that illegal search, or maybe an interrogation conducted without giving Miranda warnings as the poisonous tree.
Okay, the illegal act is the poisonous tree.
Right. Then any evidence that is later discovered because of that initial illegal action is considered the fruit of that poisonous tree.
So evidence derived from the first illegal act.
Exactly. If the evidence is sufficiently linked to an unconstitutional police action, then that evidence is also inadmissible. It's tainted by the original illegality.
Can you give an example?
Sure. Let's say police conduct an illegal search of your house and find a diary mentioning a hidden safe. Then, based only on that diary entry, they get a warrant for the safe and find illegal items inside.
Okay.
The items in the safe might be considered fruit of the poisonous tree because the only reason the police knew about the safe was from the initial illegal search of the diary, the poisonous tree. So even the evidence from the safe might get excluded.
Wow. So it prevents police from using an initial violation to build their case further down the line.
Precisely. It ensures law enforcement can't simply build a case on the back of an initial constitutional violation, no matter how indirectly the later evidence was obtained. The goal is to remove all benefit from the illegal conduct.
That seems like a really strong protection for individuals.
It is. It's fundamental to keeping police power in check.
Does Texas law specifically address this? Or is it just based on the federal rule from MAP?
Texas law explicitly codifies this principle. Code of Criminal Procedure, section 38.23a is very clear.
What does it say?
It states, no evidence obtained in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States shall be admitted in evidence against the accused on the trial of any criminal case.
That sounds like a direct reflection of the exclusionary rule right there in Texas statute.
It is. It's a powerful statement making the rule crystal clear under state law as well.
But is it absolute? Are there any exceptions where illegally obtained evidence might still come in?
Yes. There's a crucial nuance, an important balancing act here. The good faith exception.
Good faith exception.
This is found in the next part of that same Texas statute, CCP section 38.23b.
What does the exception allow?
It allows evidence to be admitted even if there was some technical violation, if the evidence was obtained by a law enforcement officer acting in objective good faith reliance upon a warrant issued by a neutral magistrate based on probable cause.
Okay, break that down. Objective good faith reliance on a warrant.
The key phrase there is objective good faith. It means the officer must have honestly and reasonably believed they were acting legally, specifically because they were relying on a warrant that seemed valid, even if it later turned out to have some technical flaw.
Objective means it's not just what the officer thought, right?
Exactly. It's not subjective. An officer can't simply claim, oops, I didn't know, or I was confused. Their actions must be objectively reasonable.
Meaning what?
Meaning a hypothetical impartial observer, someone who understands the legal requirements for a warrant, would look at the situation and conclude the officer's reliance on that warrant was reasonable under the circumstances.
Can you give an example of when this might apply?
Yeah, sure. Imagine a police officer gets a search warrant from a judge. The officer executes the warrant, follows all procedures correctly, and finds evidence. Later, it's discovered the warrant application had a minor technical error made by the issuing magistrate. Maybe a date was typed incorrectly, something the officer wouldn't likely notice.
Okay.
If the officer executed that warrant in good faith, reasonably believing it to be valid, the evidence they found might still be admissible under this good faith exception, even though the warrant was technically flawed.
But what if the mistake was obvious?
Then the exception likely wouldn't apply. For instance, if a warrant clearly specified searching 123 Main Street, but the officer searched 125 Main Street instead, they couldn't claim objective good faith reliance on the warrant because the error was clear on its face. Their action wouldn't be objectively reasonable.
So this exception tries to balance things, deterring misconduct versus practical reality.
Exactly. It balances the need to deter deliberate police misconduct with the practicalities of law enforcement. It allows evidence obtained under an honest but perhaps mistaken belief in a warrant's validity to be used.
It shows a system trying to be fair, allowing for minor, innocent errors, while still aiming to ensure justice isn't built on deliberate rights violations.
That's the tightrope it tries to walk.
Okay, let's zoom out a bit now. We've talked amendments, arrest, bail, evidence rules. Let's look at the bigger picture, the structure of the criminal justice system itself. How is it organized?
Good idea. You can think of the criminal justice system as being built on three core components: While they're distinct in their main jobs, they interact constantly, forming this dynamic, interconnected ecosystem.
Three opponents. Okay, what are they?
First, you have law enforcement.
The police.
Right. These are the agencies responsible for investigating crimes, apprehending suspects, and generally maintaining public order.
And there are different levels of police, right?
Absolutely. There are four main levels. You've got city police, like your local municipal PD, enforcing city ordinances and state laws within city limits.
Okay.
Then county-level law enforcement. This includes the sheriff's office, which usually has jurisdiction over the entire county, especially the unincorporated areas, and also runs the county jail. And in Texas, you also have constables.
Constables, what do they do?
They are also peace officers with county-wide jurisdiction, but they often have specific duties like serving warrants, subpoenas, and acting as bailiffs for the justice of the peace courts. Both the sheriff and constable roles are actually created by the Texas Constitution in Article 5.
Interesting. Okay, city, county. What's next?
State level. Think the Texas Department of Public Safety, or DPS. This includes the Texas Rangers, who handle major investigations, and the Highway Patrol, focusing on traffic enforcement and safety on state roads.
Got it. And the fourth level?
Federal law enforcement. Agencies like the FBI, investigating federal crimes, the DEA, focusing on drug enforcement, Homeland Security agencies like Border Patrol or ICE, dealing with immigration and border security. Each has its own specific jurisdiction and focus.
Okay, so law enforcement is component one. What's number two?
Component two is the courts.
Where the legal battles happen.
Exactly. These are the bodies that interpret the laws, adjudicate the cases, meaning they preside over the legal process, and ultimately determine guilt or innocence.
And like law enforcement, there are different levels of courts, too.
Yes, you have municipal courts for city-level issues, county courts for misdemeanors and appeals, state district courts for felonies, courts of appeals to review decisions, and the highest state courts, plus the whole federal court system running in parallel. They form the arena where legal arguments are made, evidence is presented, and decisions about guilt, innocence, and sentences are handed down.
Okay, law enforcement courts. What's the third component?
Finally, we have the correctional system.
Prisons and jails.
Yes, but it's broader than just that. This component handles the administration of punishments handed down by the courts. It also includes efforts towards rehabilitation and, ideally, the eventual reintegration of individuals back into society.
So what forms does this take?
It varies widely. It can be municipal fines for very minor offenses. It includes county jails, typically holding people awaiting trial or serving sentences for misdemeanors. State prisons house those convicted of more serious felonies. And it also includes community-based supervision like probation, where someone serves their sentence in the community under supervision instead of incarceration, and parole, which is supervised release after serving part of a prison sentence.
So law enforcement, courts, and corrections. These three form a kind of pipeline.
You can think of it that way. A sequential pipeline through which individuals might move once accused of a crime from the initial police contact through the court process and potentially into the correctional system and maybe eventually back out into society.
But you also said they're interconnected. It's not just a straight line.
Not at all. It's truly an interconnected web. A change or pressure point in one area creates significant ripple effects throughout the others.
How so? Give me an example.
Okay, think about law enforcement activity. If police decide to significantly increase arrests for a particular type of crime, maybe minor drug possession or public order offenses,
Okay.
what happens next? That directly translates to an increased workload, heavier dockets for the courts, more cases flood into the system.
Which slows things down, potentially.
It can, absolutely. And it strains court resources, judges, prosecutors, public defenders, court staff.
And think about the different types of enforcement. A city police crackdown versus, say, a federal initiative.
That's a perfect contrast. Imagine a city police war on drugs focusing on street-level dealing. That means busier municipal and county courts, more people potentially filling up the local county jail while awaiting trial or serving short sentences.
Right.
Now, compare that to enhanced federal border enforcement focusing on, say, human trafficking or large-scale drug smuggling. More federal arrests there mean more cases clogging up the federal courts, and potentially an increased strain on federal detention facilities and prisons. The priorities of one arm of the system directly impact the others downstream.
Okay, that makes sense. What about the connection between courts and corrections?
That's another direct link. The outcomes of court cases, what we call dispositions, directly determine the population in correctional facilities.
Oh.
Well, think about how cases get resolved. If there's a trend towards more plea bargaining, where cases are settled without a trial, often with agreed-upon sentences that might be shorter,
Uh-huh.
or if prosecutors decide to dismiss more cases outright due to lack of evidence, or if more defendants are found not guilty at trial.
That means fewer people going into jail or prison, or maybe for shorter terms.
Exactly. Fewer convictions or shorter sentences generally mean lower correctional populations. Conversely, if courts get tougher, issue longer sentences, or reduce plea bargaining, correctional populations tend to rise. Court decisions literally shape who is in prison and for how long.
It's a direct flow.
A very direct flow.
And does the connection work the other way, too? From corrections back to law enforcement?
It does, completing the cycle. Individuals being released from the correctional whether they served their full time, got out on parole, or were released early,
Yeah.
their success or failure back in the community impacts law enforcement. If rehabilitation efforts within the correctional system were insufficient, or if support systems like housing, job training, and mental health care aren't available outside,
They might reoffend.
unfortunately, yes. Recidivism or reoffending is a major challenge. And when someone reoffends, they often come back into contact with the police, restarting the whole cycle through law enforcement, courts, and corrections again.
Wow. So it really highlights that the criminal justice system isn't just a series of isolated silos. Police over here, courts over there, prisons somewhere else.
Not at all. It's a dynamic, interdependent ecosystem. A change in police policy, judicial sentencing trends, funding for correctional rehabilitation programs, any shift inevitably creates ripple effects throughout the entire system.
That's a really important perspective.
Yeah.
But the system isn't just affected by its own internal parts, right? There are outside forces acting on it, too.
Absolutely. The criminal justice system doesn't operate in a vacuum. There are powerful external influences constantly shaping it.
Like what?
Well, for one, think about rulings from the U.S. Supreme Court. We already talked about Mapp v. Ohio and the exclusionary rule.
Right, how that changed police procedures everywhere.
Exactly. Decisions by the Supreme Court set legal precedents that all lower courts and law enforcement agencies across the entire country must follow. These rulings can fundamentally alter how evidence is collected, how arrests are made, how trials are conducted, even how punishments are administered. A single Supreme Court ruling on, say, what constitutes an illegal interrogation can immediately change police practices in every state and city.
So the courts themselves are influenced from above. What else?
Then you have the legislature, Congress at the federal level, and the state legislature here in Texas.
The lawmakers.
Right. These legislative bodies are constantly creating new laws, amending old ones, and sometimes repealing laws altogether. The criminal justice system is then bound to enforce and interpret whatever laws the legislature passes.
So they define what's a crime, set the punishments.
Exactly. They define crimes, set sentencing ranges, allocate funding for police departments, courts, and prisons, establish court structures, create new rules of procedure. Their decisions can lead to new things being criminalized, old crimes being decriminalized, or sentences being made harsher or lighter, all of which profoundly impacts the day-to-day work of the criminal justice system.
Okay. Supreme Court, legislature, any other major external forces.
And finally, a crucial, often overlooked influence, the people, us, the public.
How do we influence it? Besides, being the ones potentially going through it.
We have significant influence through direct involvement. Think about serving on a jury.
Right. Juries make the ultimate decision on guilt or innocence in many cases.
Exactly. That's direct public power within the system. Or think about community activism, people advocating for policy changes, police reform, different approaches to crime and punishment. That can put real pressure on lawmakers and system actors.
But what about the flip side? What if people aren't involved?
That has an influence too, often indirectly. Voter apathy, for example. If citizens aren't engaged in elections, they might not elect leaders like district attorneys, judges, sheriffs, legislators who prioritize certain aspects of justice reform, accountability, or specific crime-fighting strategies.
So inaction can shape the system just as much as action.
In a way, yes, it broadens your understanding. The CJ system is constantly influenced by forces outside its direct operational components, legal precedent, political decisions, and public opinion or apathy. It really emphasizes its role within a larger democratic society that, ideally, requires public participation and oversight.
That paints a much richer picture. Now, let's make this concept of jurisdiction, who has authority, really tangible. You mentioned different levels of law enforcement. Let's walk through a couple of complex, maybe confusing, real-world scenarios.
Sounds good. These can get tricky, but they illustrate the principles well.
Okay, scenario 1. Imagine you're at the scene of a single-car traffic fatality. It's on a major 4-lane highway. The driver lost control, spun, rolled over, and was tragically thrown from the vehicle.
Okay, a serious accident.
Here's the jurisdictional puzzle. The driver's body lands off the roadway, specifically on a federal military reservation adjacent to the highway.
Federal land, that's key.
Meanwhile, the car's skid marks clearly started inside the city limits of a nearby town.
City limits, got it.
But the car itself, after rolling, came to its final resting place outside the city limits, in the unincorporated area of the county.
Outside city, in the county, okay.
So units from the local city police department, the county sheriff's office, the military police from the reservation, and the State Department of Public Safety, DPS, all arrive on scene. What a mess. Who's in charge?
Laughs. Yeah, that's a classic jurisdictional nightmare for the officers on scene, but a fascinating puzzle for us to untangle. This is where knowing the distinct roles and territories of these agencies is absolutely critical.
Okay, let's break it down. The body landed on the military base.
Right. Given that the body landed on a federal military reservation, the military police would definitely have jurisdiction over the body itself and that specific piece of federal land.
So they'd secure that area, handle the deceased.
Most likely, yes. They would secure that scene and potentially lead the investigation into the fatality itself, particularly concerning the deceased person found on their property.
Okay. What about the skid marks back in the city?
The skid marks starting inside the city limits would undoubtedly trigger the involvement of the local city police department. They would have jurisdiction over that initial point of impact or loss of control and any evidence found within their municipal boundaries. They'd document that part of the incident.
Makes sense. And the car ended up in the county, outside the city.
Precisely. Because the car's final resting place is outside the city limits, squarely in the unincorporated county area. The sheriff's office, as the primary law enforcement agency for those areas, would have a significant role.
They'd investigate the car itself and that location.
Yes, they would investigate the scene where the vehicle came to rest. Plus, because this whole thing happened on a major state highway...
DPS gets involved, too.
You bet. The Department of Public Safety, or DPS, which includes the Highway Patrol and specializes in serious traffic incidents and reconstructions on state highways, would also be heavily involved. Often, in complex accidents like this, DPS might take the lead on the overall accident reconstruction itself.
So you have immediate overlapping jurisdictions here. City police, sheriff, military police, DPS, all potentially involved. How do they sort it out?
Coordination is key. These agencies usually have to coordinate very closely. Often they have pre-existing agreements called Memorandums of Understanding, MOUs, that outline how they'll handle situations like this.
So they decide who takes the primary lead.
They determine who has primary jurisdiction based on the most significant legal nexus, essentially, where the most critical part of the incident occurred, or who has the primary responsibility based on statute or agreement. It often involves intricate cooperation, sharing information, and deciding who takes the lead on different aspects of the case, like MP handling the body, city handling the initial cause, sheriff handling the car's final location, and DPS doing the overall reconstruction. It's a team effort, ideally.
Wow. Okay, that shows how complicated it can get. Ready for scenario 2?
Let's do it.
All right. A body is found floating in the Rio Grande River. This is near a small, currently unused international bridge connecting Texas to Mexico.
Rio Grande River international boundary. Okay.
A member of the U.S. Border Patrol spots the body, pulls it from the water, and it now lies along the cement levee on the U.S. side of the river. At this specific location, the river itself is considered the international boundary. Who handles this?
This one immediately screams federal jurisdiction, even louder than the last one.
Why? Because of the international border.
Exactly. Since the body was found in an international boundary river and initially recovered by Border Patrol, which is a federal agency, the case likely falls primarily under federal authority from the get-go.
So Border Patrol is involved because they found it? Who else?
Well, if there are any signs of foul play or if the person's identity or cause of death has international implications, the Federal Bureau of Investigation, the FBI, would almost certainly become involved.
Why the FBI?
The FBI has jurisdiction over many crimes that cross state or national borders or occur on federal land or international waters under U.S. jurisdiction. A death investigation on an international boundary clearly falls into that realm.
So even though the body is now physically on the U.S. side of the border, the fact that it was in the international river elevates it beyond typical local or state police.
Generally, yes. The origin point in an international river, the recovery by a federal agency, the potential international implications all point strongly towards federal-led jurisdiction.
Would local police or the sheriff even be involved at all?
They might certainly assist. Local authorities, like the county sheriff or perhaps state DPS investigators, might provide resources, help secure a wider perimeter, or offer local expertise. But the primary investigation, especially if foul play is suspected, would almost certainly be led by a federal agency like the FBI, likely working closely with Border Patrol.
These complex examples really do make that abstract concept of jurisdiction very tangible. It shows you how agencies have to navigate these intricate rules and often overlapping boundaries to figure out who has the legal authority in any given situation.
It's a constant dance of coordination, legal definition, and sometimes, unfortunately, turf battles, although ideally cooperation prevails.
Okay, let's turn our attention now to how justice is actually administered. Let's navigate the court system itself, focusing specifically on the structure here in Texas. You mentioned it's like a hierarchy.
Yes, think of it like a pyramid or a ladder. Cases typically start at the bottom levels, and if appealed, can work their way upwards, layer by layer, potentially reaching the highest courts.
So what's at the very top?
Well, at the absolute top of the entire U.S. legal system, you have the U.S. Supreme Court in Washington, D.C. It's the court of last resort for both federal cases and state cases that involve a federal question, like a violation of the U.S. Constitution.
Okay, but focusing on the Texas state system, what's at the top here?
This is where Texas is a bit unique. Texas actually has two highest state courts.
Two? How does that work?
Yes. First, you have the Texas Supreme Court. But, crucially, it is the highest civil appellate court in Texas only.
Civil cases only, like lawsuits, divorces, contract disputes.
Exactly. It does not handle appeals in criminal cases. Its focus is entirely on civil law, interpreting the Texas Constitution on civil matters, and administrative issues within the state.
So it's a criminal case in Texas. Where does the final appeal go?
For criminal cases, the highest state court is the Texas Court of Criminal Appeals.
Court of Criminal Appeals. Okay, makes sense by the name.
Right. This court hears criminal appeals exclusively. And notably, it has mandatory direct appellate jurisdiction over all death penalty cases from the trial courts.
So death penalty cases skip the intermediate courts and go straight there.
Yes. They bypass the intermediate appellate courts. For all other criminal matters, the Court of Criminal Appeals is the final arbiter within the Texas state system, the court of last resort for state criminal law.
Okay, two highest courts. Supreme Court for civil, Court of Criminal Appeals for criminal life. What's below them?
Below these two highest courts are the intermediate appellate courts, known simply as the courts of appeals. Texas is divided geographically into several appellate districts, each with its own court of appeals.
And what do they do?
They hear appeals for both civil and criminal cases that come up from the trial courts within their geographic district.
So they review the lower court's work.
Exactly. They have no original jurisdiction, meaning they don't conduct trials or hear cases for the first time. Their sole function is to review the records of the lower courts to determine if any legal errors were made that might require reversing the decision or ordering a new trial. All appeals from the main trial courts flow here first, except for those direct death penalty appeals we just mentioned.
Okay, so that's the appellate level. Now let's get down to the trial courts, where cases actually begin. What's the main felony trial court?
The workhorses for serious cases are the district courts.
District courts, okay. What kind of cases do they handle?
They have original jurisdiction, meaning they are the first court to hear the case over all felony offenses.
Felony is the most serious crimes, right? Murder, robbery, major drug offenses.
Correct. All felonies start in district court. They also handle cases of official misconduct, which involves crimes allegedly committed by public officials in their official capacity. And they handle major civil cases, too, involving large sums of money or significant legal issues like land disputes.
Do they hear appeals from lower courts?
Generally, no. District courts primarily have original jurisdiction. They do not typically hear appeals from the county-level courts, although cases can sometimes be transferred between courts under specific circumstances.
Okay, so district courts for felonies and major civil cases. What's the next level down for less serious criminal cases?
Next, you have the county courts at law.
County courts at law. Are these in every county?
Not necessarily the constitutionally mandated county court presided over by the county judge, which has limited judicial duties in many counties, but these specific county courts at law are created by the Texas legislature in more populous counties to handle the judicial workload.
Okay. And what kind of cases do they hear?
They generally hear the more serious misdemeanors, specifically Class A and Class B misdemeanors.
Examples, like DWI, assault causing minor injury, theft of smaller amounts.
Exactly. Things less serious than felonies, but still carrying potential jail time, up to a year in county jail, and significant fines. They also handle smaller civil matters.
Do they hear appeals?
Yes, this is important. County courts at law do hear appeals from the lowest level courts, the justice courts and municipal courts. So they act as the first level of appeal for those very minor cases.
Okay, so they handle serious misdemeanors and appeals from a bottom tier. What is that bottom tier?
At the base of the pyramid, you have two main types of courts handling the least serious offenses: justice courts and municipal courts.
Justice courts first. What's their jurisdiction?
Justice courts, often called JP courts for the justice of the peace who presides, have jurisdiction over Class C misdemeanors.
Class C. Those are the least serious.
Right. Generally punishable by a fine only, no jail time. Think minor traffic violations, public intoxication, disorderly conduct, things like that. They also handle small civil claims, like small debts, eviction cases, and perform magistrate duties like issuing warrants and setting bail in the early stages.
And you mentioned these are created by the Texas Constitution.
Yes, unlike the county courts at law, which are created by the legislature as needed, the existence of justice courts is mandated by the Texas Constitution itself, highlighting their fundamental role in providing local access to justice.
Okay. And the other bottom tier court?
Municipal courts.
Right, municipal courts. These are the courts established by cities and towns.
What do they handle?
Their primary job is handling violations of city ordinances, things like parking tickets, zoning violations, noise complaints, animal control issues, laws specific to that city. Do they handle state law violations too?
Yes, they also have jurisdiction over Class C misdemeanors committed within the city limits, sharing that jurisdiction with the justice courts. So that speeding ticket you get from a city cop could potentially go to either the municipal court or the JP court in that precinct.
Ah, okay. So shared jurisdiction for Class C state offenses, but only municipal courts handle city ordinance violations.
Correct. Municipal courts have sole jurisdiction over municipal ordinance cases. You can't take a city parking ticket dispute to the justice court.
Got it. Are there any other courts we should know about?
Just briefly, we should mention specialized courts like small claims court, which is often part of the justice court system, and handles civil disputes involving very small monetary amounts, making it easier for people to resolve minor disputes without lawyers. And juvenile court, which handles cases involving minors accused of delinquent conduct or children in need of state protection. These are technically civil proceedings, not criminal.
So this whole tiered system, from municipal JP up to the two Supreme Courts,
Sure.
it's designed for efficiency.
Efficiency and appropriate handling. It ensures that the most serious cases go to the courts equipped to handle them, district courts, while minor offenses and disputes are handled locally and more quickly at the lower levels, JP and municipal, with layers of appeal available to review decisions.
You mentioned concurrent jurisdiction between JP and municipal courts for Class C misdemeanors. Does that happen elsewhere?
It can, yes. Concurrent jurisdiction just means that more than one court has dual or shared original jurisdiction for the same offense. The JP municipal overlap on Class C state law violations is the most common example at the lowest level. Higher up, there can sometimes be overlapping jurisdiction between different types of county or district courts depending on the specific statutes involved, but the basic hierarchy generally holds.
That clarifies the structure really well. Now, let's zoom in on those figures who often provide the first point of judicial contact, magistrates. What exactly is their role?
Magistrates are absolutely critical, especially in the early stages of a criminal case. An examining court, as defined by CCP Section 2.11, is simply the setting where a magistrate sits for the purpose of inquiring into a criminal accusation against any person. They are the initial judicial gatekeepers.
So who are magistrates? Is it just another word for judge?
Not exactly. While many judges are magistrates, the term magistrate in Texas law, under CCP Section 2.09, actually includes a surprisingly broad list of officials. It's designed to ensure that someone with judicial authority is available promptly to handle those initial duties, like arraignments and warrants, especially in large or busy areas.
So who's on the list besides typical judges?
Well, of course, it includes judges from all the appellate courts, the Supreme Court, Court of Criminal Appeals, Courts of Appeals, and all the district court judges. But it also extends down to county judges, judges of the county courts at law, county criminal courts, even judges of statutory probate courts.
Okay, still mostly judges. Anyone
Right.
else?
Yes. It includes justices of the peace, the JPs we just talked about. And importantly, it also includes mayors, recorders, and judges of municipal courts in incorporated cities or towns.
Mayors can be magistrates.
In Texas, yes, mayors of incorporated cities can have magistrate duties, particularly regarding initial appearances or issuing certain warrants related to city ordinances or breaches of the peace within their city. The list even includes various specialized appointed judges or hearing officers in specific large counties created by statute to help handle the criminal caseload.
Wow, that's a much broader group than I would have thought.
Uh-huh.
So what are their core duties? What does a magistrate do?
Their core responsibilities are laid out in CCP Section 2.0. They have three main duties. First, to preserve the peace within their jurisdiction. They act as local guardians of order.
Okay. Second.
Second, to issue all process intended to aid in preventing and suppressing crime.
Process, meaning legal documents.
Exactly. Things like arrest warrants, search warrants, summonses to appear in court, the legal paperwork needed to initiate or continue legal action against someone suspected of a crime.
Got it. And the third duty?
Third, to cause the arrest of offenders in order that they may be brought to punishment. This ties into issuing warrants and basically authorizing the actions that bring individuals formally into the justice system after probable cause is established.
So they review probable cause, issue warrants, conduct those initial arraignments, set bail. They're really crucial at the front end.
Absolutely. They ensure the process begins lawfully, reviewing police actions and informing defendants of their rights, setting the stage for everything that follows.
You mentioned warrants. How far does a magistrate's warrant reach? If a JP in one county issues a warrant, is it good anywhere in Texas?
Generally, yes. Under CCP Section 15.06, an arrest warrant issued by most magistrates, like judges of district courts, county courts, or JPs, extends to every part of the state. A peace officer from anywhere in Texas can generally execute that warrant.
But are there exceptions? You mentioned mayors earlier.
Yes, there's an important distinction primarily for warrants issued by mayors or certain other very local officials like recorders of municipal courts. Their warrants are initially limited in scope.
How so?
Warrants issued by city or town mayors are typically valid only within the county where that city is located, unless they get endorsed.
Endorsed. What does that mean?
It means another higher-ranking judicial official essentially co-signs it, validating it for broader execution, as outlined in CCP 15.07.
How does the endorsement work?
A mayor's warrant can become valid statewide if it's endorsed by a judge of a court of record, like a district court judge adds their signature. Or it can become valid in one specific county where the accused person is found if it's endorsed by any magistrate in that particular county.
So it adds a layer of judicial review before a very local warrant can be executed far away.
Exactly. It ensures that warrants issued by officials with perhaps more limited legal training or scope are reviewed before having statewide effect, maintaining a balance between local authority and broader enforcement needs.
That makes sense. Okay, now, we know magistrates issue warrants, and warrants are generally needed for arrests or searches.
Yeah.
But police can arrest without a warrant sometimes.
Yes, absolutely. While warrants are generally preferred under the Fourth Amendment, reflecting a judicial check before the arrest, police officers in Texas have specific statutory powers to make arrests without a warrant in certain defined situations.
When would that happen?
Usually it requires the officer to have probable cause, that reasonable belief that a crime has been, is being, or is about to be committed, plus one of the specific circumstances outlined by law that justifies bypassing the warrant requirement, often due to urgency.
And Texas law lists these circumstances.
Yes. Texas Code of Criminal Procedure Chapter 14 details these specific situations. There are actually 11 distinct scenarios listed where an officer is authorized to arrest without first obtaining a warrant.
11. Wow, okay.
Understanding these is really crucial because it empowers you with knowledge about when and why police can make an arrest on the spot, clarifying those common scenarios we see and the legal boundaries they operate within.
That sounds incredibly important for citizens to know. Can we walk through these 11 situations?
We absolutely should. They really define the scope of police authority in real-time encounters.
Okay, number 1. When can an officer arrest without a warrant?
First, if they have probable cause that a felony has been committed, and there's a reasonable belief the suspect is about to escape and there's no time to get a warrant, think urgent situations, like someone caught fleeing the scene of a serious crime. The felony plus escape risk combo.
Okay. Felony plus escape risk.
Okay.
Number 2.
Second, dealing with fugitives. If they have probable cause to believe someone is a fugitive from another state, charged with a crime punishable by death or imprisonment for more than 1 year. Again, it's about preventing escape across state lines.
Makes sense.
Right.
Fugitives. Number 3.
Third, and this is a very common one, if any offense, felony, or misdemeanor occurs within the officer's view or presence.
So if they see it happen right in front of them, like seeing someone shoplift or get into a fight or run a red light.
Exactly. If it happens in their presence or view, they generally have the authority to arrest without needing to run off and get a warrant first.
Okay, that's intuitive. Number 4.
Fourth is a bit more unusual. If a felony or a breach of the peace occurs within the presence or view of a magistrate.
A judge or JP sees it happen.
Right. And the magistrate verbally orders a peace officer to make the arrest. It's like a direct judicial command on the spot, empowering the officer.
Interesting. Okay, number 5.
Fifth, if a person admits to committing a felony to the officer and that admission is supported by other independent probable cause. So a confession plus corroborating evidence gives grounds for immediate arrest.
Confession plus evidence. Got it. Number 6.
Sixth allows a warrantless arrest to prevent the consequences of theft. This is often interpreted broadly to allow officers to arrest someone immediately caught in the act of stealing or found in possession of recently stolen property to recover the goods and stop the crime.
Preventing theft in progress or immediately after. Okay. Number 7.
Seventh is a bit more subjective. If the person is found in a suspicious place under circumstances which reasonably show they've committed a felony or a breach of the peace or are about to commit an offense, and there's a reasonable urgency demanding immediate arrest.
Suspicious place and circumstances. That sounds like it could cover a lot.
It can, but it requires that element of reasonable suspicion tied to a specific crime and urgency. Think finding someone hiding near a burglary scene late at night. It requires careful judgment by the officer based on the totality of circumstances.
Okay. Number 8.
Eighth deals specifically with assault. If an officer has probable cause to believe someone has committed an assault resulting in bodily injury to another person, and it's not family violence, which has its own rule, and the officer believes there's an immediate danger of further bodily injury to that person.
So non-family assault with risk of it continuing. Prioritizing victim safety.
Exactly. Allowing immediate intervention to prevent escalation.
Okay. Number 9. You mentioned family violence.
Yes. Number 9 is a very significant one in modern law enforcement. An officer can arrest without a warrant for any offense involving family violence.
Any family violence offense. Even a misdemeanor.
Yes. If the officer has probable cause to believe a family violence offense has occurred, they have the authority to make a warrantless arrest. This reflects a strong policy focus on protecting victims in domestic situations and giving officers clear authority to intervene immediately, even if the offense wasn't committed in their presence.
That's a powerful tool for officers in those dangerous situations. Okay, number 10.
10th is called interference with emergency request for assistance. Basically, if an officer has probable cause to believe someone intentionally prevented or interfered with another person's attempt to place an emergency call, like calling 911, or interfered with communication with law enforcement.
So stopping someone from calling for help is itself grounds for arrest.
Yes.
Yeah.
It's seen as a serious obstruction that could put someone in immediate danger, so officers can arrest for it without a warrant.
Makes sense.
Okay.
Last one, number 11.
And finally, number 11 deals with violations of protective orders, often issued in family violence or stalking cases. If an officer has probable cause to believe a person has violated certain conditions of a protective order, the law says the officer shall arrest if the violation occurs in their presence. For violations not in their presence, they may arrest based on probable cause. It underscores the seriousness of these court orders and the need for immediate enforcement when they are violated.
Shall arrest if in presence. That's strong language.
It is. It removes officer discretion in that specific scenario to ensure the protective order is enforced. So those are the 11 statutory exceptions in Texas, allowing warrantless arrests.
That's a really helpful breakdown. It clarifies when officers can act immediately and why. Now, to really cement all this court and jurisdiction information, can we apply it to a couple of final scenarios?
Absolutely. Let's test your knowledge with what we've covered about the Texas court system.
Okay, scenario 1. An individual is arrested and charged with murder. We know that's a first-degree felony under Chapter 19 of the Texas Penal Code. Let's trace its path. First question. Which Texas court would have original jurisdiction? Where does this case start?
Okay, murder, a first-degree felony. Based on our discussion in the court hierarchy, the court with original jurisdiction for all felonies is
The district court.
exactly. The district court is where the case would begin,
Yeah.
where the trial would be held, evidence presented, and a verdict reached.
Okay, now let's say the person is convicted in district court and wants to appeal. What court hews that initial appeal?
The initial appeal from a district court conviction, whether it's murder or another felony, unless it's a death penalty case, would go to one of
Courts of appeals, the intermediate ones.
Precisely. The Court of Appeals for the geographical district where the trial occurred would review the case for legal errors.
And how high could this case potentially be appealed within the Texas state judicial system? What's the final stop?
The highest court for criminal appeals in Texas is the...
Court of Criminal Appeals.
Right. If the Court of Appeals upholds the conviction, the defendant could potentially ask the Texas Court of Criminal Appeals to review the case. And remember, if the death penalty was assessed at the district court level, the appeal goes directly from district court straight to the Court of Criminal Appeals, skipping the intermediate Court of Appeals. It's the ultimate authority on Texas criminal law.
Okay. Now, one more twist on this. Under what circumstances could this state murder case potentially move into the federal court system? Is that possible?
It's possible, but only under specific circumstances. It's not a simple transfer. A state criminal case can only move into the federal system if there's a federal question involved.
Meaning a claim about the U.S. Constitution.
Exactly. Typically, it means the defendant is claiming that their U.S. constitutional rights were violated during the state court proceedings. For example, maybe they claim their confession was coerced in violation of the Fifth Amendment, or there was an illegal search violating the Fourth Amendment, or they didn't receive a fair trial as guaranteed by the 14th Amendment's Due Process Clause.
So if they raise a federal constitutional issue,
Then, after exhausting all their state appeals, going all the way up to the Texas Court of Criminal Appeals, they could potentially file a petition, usually a writ of habeas corpus, in federal court. The federal court wouldn't retry the entire murder case, but it would review whether the state courts correctly handled the specific federal constitutional claim.
got it. So it's about reviewing federal rights violations, not just disagreeing with the state verdict.
Correct. It's a specific and limited avenue for federal review of state convictions.
Okay, great. Scenario 2. Let's shift to less serious offenses. Two men are found together in a city park well after closing time.
Okay.
One man is cooperative and simply issued a Class C citation for violating the park hours ordinance. The other man is not only cited for the park violation, but is also found to be illegally carrying a handgun, and he's arrested for misdemeanor unlawful carrying of a weapon. Where would each of these men likely have to go to court?
Okay, let's take the first man, the one who just got the Class C citation for the park hours violation. That's a very minor offense. Where would he likely appear?
Class C. That sounds like the bottom tier. So either municipal court or justice court. Since they have concurrent jurisdiction,
Excellent, you got it. Because it's a Class C misdemeanor, either a state law violation like violating park rules set by state statute, or potentially a city ordinance violation, he would likely appear in either the city's municipal court or the county's justice court, JP court, for that precinct. The specific court often depends on which agency issued the ticket and local practice.
okay. Now for the second man, he got the Class C park violation citation too, but he was also arrested for misdemeanor unlawful carrying of a handgun. Let's assume that's a more serious misdemeanor, maybe a Class A. Where does he go for the gun charge?
Right. The unlawful carrying of a weapon is typically a Class A misdemeanor in Texas, which is much more serious than a Class C. It carries potential jail time. So that charge would not go to the municipal or JP court. It would go to...
The county court at law, because they handle Class A and B misdemeanors.
Perfect. The Class A misdemeanor gun charge would typically be filed in a county court at law or a specialized county criminal court if the county has one. That court has the original jurisdiction to handle trials and sentencing for these more serious misdemeanor offenses.
So he might end up dealing with two different courts. The Muni-JP court for the Class C park ticket and the county court at law for the Class A gun charge.
That's entirely possible, yes. The cases might proceed separately in the courts that have jurisdiction over each specific level of offense. These practical examples really do help solidify how the court hierarchy and jurisdiction rules work in everyday situations.
They really do. And just like that, wow, we've covered a lot of ground. We've journeyed from those foundational principles in the 8th, 9th, 10th, and 14th Amendments.
The big constitutional pillars.
Through the practicalities of bail and arrest procedures.
The rules of evidence, like the exclusionary rule.
Into the complex structure of the whole criminal justice system, police, courts, corrections, and how they interact.
And those tricky jurisdictional issues.
And finally, drilling down into the specific roles of the different courts and magistrates right here in Texas. I feel like you've gained a much deeper appreciation for this intricate web of laws governing our society.
And hopefully, for you listening, understanding these constitutional underpinnings and the structure of our justice system isn't just, academic knowledge for lawyers.
No, it feels fundamental.
It really is fundamental to being an informed citizen. It empowers you to understand your rights, to recognize the limits of governmental power, and to see how the system actually operates, how it's supposed to operate to protect or process individuals.
This knowledge truly feels like a cornerstone of just navigating our society effectively.
It allows you to engage with crucial public policy debates about police reform, bail reform, sentencing laws with a clear, informed perspective rather than just reacting emotionally.
Absolutely. So, as we wrap up, let's leave our listeners with something to think about, a provocative thought maybe.
Okay, consider this.
Yeah.
As technology advances so rapidly, think about artificial intelligence potentially assisting in bail determinations or widespread digital surveillance becoming even more pervasive.
Yeah, that's happening now.
How might these incredible innovations challenge or reshape the core principles we've discussed? Principles enshrined in the Eighth Amendment, like fair bail and no cruel punishment, or the 14th Amendment's guarantees of due process and equal protection.
Wow. Will AI-driven bail algorithms truly eliminate human bias? Or could they maybe accidentally bake in and perpetuate existing societal inequalities in new ways?
That's a huge question courts and society are grappling with. How will the concept of due process, fair procedures evolve when more and more of our lives, our movements, our communications are digitally recorded, stored, and potentially analyzed by algorithms?
What new questions might our centuries-old Constitution have to answer in a world increasingly shaped by data, algorithms, and technology the founders couldn't possibly have imagined?
It's a thought that truly shows the Constitution isn't just a static historical document. It's a living framework that has to constantly adapt through interpretation to new societal realities and technological advancements.
So we really encourage you, take this newfound understanding from our deep dive today and keep exploring.
Yeah, maybe look up the full text of these amendments yourself online. Or even better, find your own state's constitution. See how these vital principles are woven, maybe differently, maybe similarly, into the fabric of your local legal landscape.
Because the deep dive, the learning, it never truly ends, does it?
Sure, there's always more to understand about the systems that shape our lives.